Hey, y'all, and welcome to the live stream. 5 days ago, Bryan Kohberger finally revealed his alibi. But is it the perfect alibi or perfect nonsense? We're going to talk about it and you can decide. Bryan Kohberger, of course, is accused of murdering 4 University of Idaho college students in the middle of the night in the home where 3 of the college students lived. He was a graduate student attending another university about 30 minutes away. 5 days ago, he gave us an alibi. We're going to analyze it, and I'm going to give you my opinion, and I'm going to ask what your opinion is about his alibi. Now, speaking of alibis, prove you were here at this video by hitting the like button and subscribe. We'd love to have you back for more videos. Now, let's talk about first why it is that Bryan Kohberger had to give an alibi at all. So let's take a look at the statute. I'll show it to you. 19-519. It's an Idaho statute, and it says that within 10 days, we're just going to look at the first paragraph 1. The defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. So there were 2 things that Bryan Kohberger had to do to make his alibi. He had to state the specific place or places where he was and the names and addresses of witnesses who would help him by establishing that. So that was what he had to do in order to present an alibi. Now, you might think to yourself, gee, why does he have to present an alibi at all? After all, I mean, in the U.S., you don't have to prove you're innocent. The state has to prove you're guilty. It's their burden of proof. So why do you have to provide something like that at all? And the answer is because an alibi is different. It's considered different. It might seem unfair if you think about, but if you think about it, you can kind of understand why an alibi is affirmative. Now, you can win the case by the state just not making its case. But if you're going to do an alibi, that's affirmative, where you're saying, I want you to know I was somewhere else entirely. I could not have done this. And when you think about it, think about what would happen if that kind of law didn't exist. Because first of all, let's say Joe says, I didn't commit this heinous crime, this murder, because I was visiting my 4-year-old who had cancer. And so then one of 2 things could happen. Either the state needs to know that, and if in fact Joe was busy visiting his 4-year-old with cancer at the hospital, then the state needs to dismiss its case, and it needs to go about figuring out who the heck did this crime, because it wasn't Joe. Joe was somewhere else. It would be a waste of everyone's time to go to trial. But then it could go the other way too. What if Joe is lying about that alibi? Well, maybe the state could show that Joe left the hospital 5 hours before the murders, had plenty of time to do them. Or maybe that he didn't show up at the hospital that day at all. Or maybe his kid was 32 and never had cancer. Any of those things might disprove the alibi, but the state won't know to go get that evidence if the state has no idea what the claim is, that the alibi is going to be claimed. So this was not Bryan Kohberger's first, the alibi he gave 5 days ago was not his first attempt to give an alibi. The first attempt was on July 24th. And let's take a look at what he said real briefly at that time. We've covered that in another video, so we don't need to cover it in detail. But let's take a quick look at what it is that he said at the time. Oh, sorry, this is here we go. Notice of alibi. No, not that one either. Uh-oh. So darn it. Well, I hate it when I do this. I hate that. Anyway, I don't think I have that document. So the bottom line of what they said was, they said that we don't have to tell you because it's enough that the state, it's enough that Bryan Kohberger can claim his innocence without proving anything. He has the right to not self-incriminate. He doesn't have to testify, so we don't have to tell you. But that was clearly wrong under Idaho law. The law clearly said you need to give something specific in terms of the place and in terms of the time. You need to be specific about who else could testify to it and about where you were. And so that didn't happen in that original brief that was filed. And so I said that on a video. We covered that here on the channel. And the state said exactly the same thing. The prosecution said, look, that's not an alibi. So let's take a look at what the prosecution said. The prosecution asked for an order compelling the defense to provide the alibi. So in other words, the state is saying, Bryan Kohberger, you're required under the law to give us your alibi. So court, we want you to make them do that, because they didn't do it. What they provided that first time, that wasn't an alibi. That was just them saying, we'll let you know in the future, but we don't have to tell you anything more than just nothing for right now. So the state said, look, the statute's pretty specific. You need to give the specific place or places where the defendant was, and you need to give the names and addresses of all the witnesses. And if you don't do that, then court, you need to compel them to do that, because that's their responsibility. And they said, what they've done so far doesn't meet that. We have a right and a need for it. They didn't comply with that. We're really close to trial. We're just 2 months away. And we have duties that are triggered when they give the alibi. Our duty is to tell them how we're going to respond, but we can't do that if we still don't know what their alibi is. We have to be given that information in order to comply with what we have to do. And so but I'll tell you what really got the defendants going was what they said at the very end. They said, okay, compel the defense to give us written notice of the names and addresses of the witnesses. This is the paragraph that really got the defense going. Alternatively, the state prays for an order of the court pursuant to the Idaho Code section prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Now, I will be honest, when I saw that, I thought there is zero way the court is going to do that. The court is not going to say you can't present an alibi at all. The court is going to say, go ahead and tell us your alibi. That's what the court's going to say. But boy, the defense took it very seriously. They talked about that a lot in their response to this. So let's take a look at what they said in their response, because that's where we finally got an actual attempt and an alibi. And you'll make your own decision about whether you think it's any good at all. So give me a second just to queue up so I get all my documents synced up. So the motion, this was filed 5 days ago in the Idaho court. And for the first time, they did acknowledge, okay, yeah, we have to have an alibi disclosure of a specific location and the witnesses. Yes, that's right. That's exactly what the statute said. And they said Kohberger may remain silent. That's exactly true. But he anticipates corroborating witnesses. We do not know who those would be. From what he says later, I don't think it's anybody who's going to confirm his alibi in the sense that they saw him. Well, you'll see. You'll see what I won't spoil the surprise in case you haven't heard it, in case you haven't been reading the articles about it. So then they talked about this. Kohberger's team talked about some of the law around this and the thing they seemed most concerned about was that the court would exclude witnesses or exclude their alibi. They seem to be really upset about that, like that you can't do that. You can't just immediately move to keeping out the alibi. You've got to take other steps first, which I think is almost certainly true and definitely what the court would do. And here we finally got the alibi. I put it in green so it'd be easy for you to see. Mr. Kohberger has long had a habit of going for drives alone. Often he would go for drives at night. He did so late on November 12th and into November 13th, 2022. Mr. Kohberger is not claiming to be at a specific location at a specific time. At this time, there is not a specific witness to say precisely where Mr. Kohberger was at each moment of the hours between late night, November 12th, 2022, and early morning, November 13th, 2022, when the murders happened. He was out driving during the late night and early morning hours of November 12th through 13th, 2022. So his alibi is, I was out driving around alone at night in my car. And I don't know if anybody saw me or knew anything about that, but that's what I'm doing. And don't worry, we're going to talk about whether that makes any sense, about whether it helps him, whether it hurts him. We'll get to that. I'll go ahead and finish with what they said in the motion, just to cover that quickly. They said, look, what we told you right there in that paragraph I highlighted in green, that's all we can give you right now. That's the most I can tell you right now. The corroboration of the fact that Bryan Kohberger was not at the home is going to be brought out through cross-examination of the state's witnesses, they say. And at this time, we can't be more specific about the possible witnesses and exactly what they will say. The defense has been hampered by the state's own choices. The state chose a secret grand jury rather than the planned preliminary hearing. Remember, we've talked about the fact the defense is very upset about that. The defense really wanted that preliminary hearing. It would have been better from the defense standpoint because they would have actually laid eyes on the witnesses and been able to cross-examine them, as opposed to the grand jury, which did its proceedings in secret and without the defendant being present and without the defendant being able to cross-examine. So they would have liked that. And they're saying, we don't really know what we're going to ask all the state's witnesses because we don't yet know what it is that the state's witnesses are going to say. When we find that out, maybe we can let you know then. And they also say corroboration of the fact that Bryan Kohberger was not at the home where the 4 students were murdered may be brought out through expert witness presentation. That analysis is underway. In other words, Bryan Kohberger may hire expert witnesses probably related to the cell phone, almost surely related to the cell phone and its presence, maybe to some footage of the Hyundai Elantra. We don't know a lot about what exactly the state has on where the Hyundai Elantra was. We don't know how many sightings they have or how much video they have of that. We just have sort of the bare bones of that for right now. The defense had to obtain a court order to receive relevant discovery material. So this is another complaint by the defense. They're saying, look, you haven't been giving us discovery, and we may be able to figure out more about what experts we want, but we can't do that until we know what exactly your case against Bryan Kohberger is. So it's your fault, state, that we haven't been able to do this. And the defense adds, the defense has stated all that can firmly be stated at this time. This is the defense requesting information as quickly as possible, yet in some instances face the delay of requesting a court order to obtain information. And I'll go ahead and read the next sentence and then we'll talk about this paragraph. The state continually uses those opportunities to attempt to force a waiver of speedy trial. So the defense is saying, we keep asking you for the information, state, and the state is delaying giving it to us. They're doing this as a tactic. This is the defense argument. The state is doing this as a tactic because they want to force us to realize we cannot conceivably be ready for trial in 2 months. And so then we waive our right to speedy trial. They're trying to force this by not giving us information that they know good and well we ought to get. That's the defense argument that's being made. And then they ask for this. Mr. Kohberger requests such an exception at this time. Mr. Kohberger is prepared to provide further detail in an ex parte hearing with the court. Okay, now first, what do they mean by the exception? Kohberger requests an exception. I think what they're referring to, we'll go back to the statute. Paragraph 5 said, for good cause shown, the court may grant an exception to any of the requirements of subsections 1 through 4. I think what they're saying is that that the court has the power to say Bryan Kohberger doesn't have to produce an alibi and lay off him, state, just deal with it at trial. The comment, though, Mr. Kohberger is prepared to provide further detail in an ex parte hearing with the court. Super interesting. Ex parte hearing, huh? That's really interesting. Let me tell you what an ex parte hearing means. What the ex parte hearing is when one party meets with the court alone. The party and the judge and the other party isn't present, or the other parties aren't present. It's ex parte, and it means that the only people present in the room don't include all of the parties to the lawsuit. And for obvious reasons, courts are very reluctant to do that because it can obviously look like the court is colluding with one of the parties. Why did they exclude somebody? What happened in that secret meeting? Why weren't we included? Those are obvious questions. Courts are very reluctant to do anything ex parte. It's very unusual. It's not the norm. So I found it kind of funny that they were saying they were prepared to provide further detail. It's not unheard of. I mean, the court sometimes will do that. Sometimes both sides will agree that there's something that should be submitted ex parte to the court, and they'll agree to that for a perfectly good reason, that they believe it could be confidential and they want the judge to rule on it. But there's not really a lot of information here about what the further detail would be. Further detail about what? Further detail about driving around alone? Further detail about why they aren't able to respond, or about why they can't get experts? None of that's really clear. What is it that they think that they would tell the court? So I would think without a lot more detail about why they want to provide this information and what information they want to provide to the court, that's pretty unlikely the court's going to meet with them ex parte. And that's like not just where we, the public, can't see it. That happens all the time. But this is where the prosecution wouldn't even be present. And it's something that the defendant is saying, look, this is part of our, probably, at least I think they're saying, this is part of our trial prep. And we can't let the state know it because it will give away this secret. So what is the secret? We don't know. But we do now know the alibi. So let's talk about the defensive driving alibi. That's what I'll call it. Now, I want to do sort of an upside and a downside of it, because I want you to be able to think of it for yourself and what do you think about it. Now, on the one hand, I do want to commend the defense for leaning into the problems in the case. They only gave up what they were almost surely going to lose anyway, because the state has video, at least video clips, photographs of the Hyundai Elantra driving around at night. They have Bryan Kohberger's cell phone leaving his house, and then they have it stopping responding. Then they have it turning on again before it gets to his house. And that's that period in the middle, the state says, is when the murders were committed, and they say he turned off his phone on purpose because he didn't want to be tracked. This was all part of his plan to escape being discovered for having committed these murders. So it would have been very difficult for Bryan Kohberger to have argued that his cell phone was somehow out on the street, away from his apartment, going away and coming back. That would have been pretty hard for him to argue. It would have been hard for him to say why exactly his cell phone pinged from certain towers. Why was a Hyundai Elantra seen leaving the area where he was? Why was it seen in other places? It would have been a tough sell for Bryan Kohberger to say none of that stuff happened. So I acknowledge. So what Bryan Kohberger did is just say, okay, we acknowledge where we can't win and where the state is going to win, and we're going to try to neutralize it. And the second thing I want to say is it's apparently all they had. They didn't have someone, he wasn't with his girlfriend at such and such address and she can come in and testify. He didn't have something. I personally do believe strongly in the presumption of innocence. And just for a minute, and I realize it can be hard when a lot of evidence has been presented, but kind of imagine that this is true. Imagine that there's just some defendant somewhere with super bad luck and he couldn't sleep. He really did decide to drive around in his Elantra. He really did drop his charger and couldn't find it. And the cell phone went dead, just an accident. And what if that really happened? Then and he also is going to say it's kind of bizarre that there was just this one piece of DNA at the scene. Like, why wouldn't there have been a lot? Huge bloody scene, knife. Why wouldn't there have been a lot of evidence at the scene? And so the defense is going to say, look, this is what we got. He was driving around. That's just the way it was. He, in fact, was driving around. And the only evidence tying him to the actual scene is this DNA on the knife sheath that was found underneath Madison Mogen's body. That's it. That's what they're going to argue. All right. Now, but on the other hand, this is really not much of an alibi. It really is not what any attorney would be hoping the client would have in terms of an alibi. This is, I'll go through four kind of big problems that I can see that he's going to have with this alibi. The first is it's not really an alibi, because an alibi is where you put yourself away from the scene of the crime at the time it happened. Well, instead, he put himself headed toward the scene of the crime, and he has apparently, at least at this time, no witnesses to say he was somewhere else when the murders were committed. All he has so far is he was headed in that direction, and that's it. So the second thing is he's helping the state prove one of the hard parts of their case. He didn't live in Moscow. It was the middle of the night. He would presumably be in bed. He wasn't known as a partier. So the state had to get him up in the middle of the night, out in his car, driving near the scene of the murders. And so when you think about it, step one of the state's case is murderer got in the car alone, drove around in the middle of the night in order to commit murders. And ironically, that is also the alibi that Bryan Kohberger has. Got in my car alone, drove around in the middle of the night toward the scene of the murders, but didn't commit them. So he's now admitted that he was awake, that he was out, that he was in his Hyundai Elantra, that it was his phone, that his car did go toward Moscow. Now, let me correct that. He hasn't said that was my phone. He hasn't admitted in the sense of saying this is my Hyundai Elantra, but essentially his alibi allows for all of that to be true. So then the third problem I see is that the cell phone remains a problem for the state, at least somewhat, because they apparently, based on what they filed initially, weren't able to put the cell phone in the home. It just wasn't that precise, but because it had been, they say, turned off. But that's a smaller issue now because Kohberger has handed them both that he was out in his car and the direction he was headed. He was headed in the right direction toward that. So that decreases the problem for the state of proving that he was actually present at the scene. Now, I would expect Bryan Kohberger to say, just as I mentioned a minute ago, the phone went dead. I just dropped my charger, and then it rolled out from under the seat as I was nearing my, as I was at some other spot. And I was like, oh, great, there's the charger, plugged it in. My phone came back on, and that's why it came on later. It was dead in the middle. It had nothing to do with me trying to conceal this evil intent I had to go out and murder people. It just went dead like anybody's phone would do. That's what the defense, I think, is likely to argue. Now, the fourth problem, I think, is that it opens up an argument for the state. Why was Kohberger driving around in the middle of the night by himself with no one able to say they saw him at any point, no gas station stop, not even, midnight munchies kind of a stop, nothing. There's no one who can say, yes, we saw Bryan Kohberger out and about, and he wasn't at the scene of the murders. So why was he driving around in the middle of the night? What was his reason? And of course, he doesn't want to testify. So that will have to, or at least I assume he probably won't want to testify. And so that's going to have to come in through questions. Well, isn't it possible that Mr. Kohberger, objection, possible speculation, it's going to be more difficult to get that theory in than it would have been if this wasn't even an issue. But now there's going to be an issue because it's opened up an argument for the state about why on earth he was doing this crazy thing of driving around in the middle of the night. So I think that the defense figured, what choice was there really? What choice did we really have? Because the state had the initial part, his phone headed in the right direction and the Hyundai Elantra. So what have we given them really? Nothing. We haven't given them anything. We've just admitted what we couldn't win anyway, and that's therefore not that big a deal. It's not that big a problem for us. We can live with that. But like I said, on balance, it's not much of an alibi either. So as a lawyer, what you're hoping for is your client to say, here is a photo of my client feeding 200 homeless people 500 miles away at the exact moment of the crime. But this isn't even remotely close to that. It is really, really far from that. So I really would like to know, what is your opinion? What do you think about this alibi? Are you persuaded? Do you think it's nonsense? What do you think about it? I'm very curious. So if you've enjoyed the video, please do hit the like button, and you definitely want to subscribe because we have such a huge week coming up. You don't want to miss anything we're doing this week. The highlight of the week is going to be Wednesday when we have a very special guest. We're going to have John Ray on. He represents two of the families of the Gilgo Beach victims, not the victims who have actually been charged against Rex Heuermann. He represents two families, and no one has yet been blamed for their murder. So we're going to be talking to him. He believes there was a conspiracy, that a woman was involved in at least some of the murders. And so we're going to talk to him about what he thinks is happening with the other victims, the ones who have not yet been charged. Is the state any closer to figuring out who killed those other victims? Is the state any closer to figuring out whether there was a conspiracy and who might have been involved in the conspiracy? We're going to be asking him all that. I'm going to put this out. I'm going to put this on our community page. So you definitely want to subscribe so you get the community posts. And so I'm going to put that out and ask you for questions, but we only get them for half an hour, only 30 minutes. So I'm not going to be able to ask very many questions. I'm just going to have to pick a few of the absolute best questions. So I'll ask you, what are some of your ideas about what are the best things we could ask him with our 30 minutes? We're very lucky to have him for that. I'm also working on 2 brand new videos that I think I'm going to drop as videos instead of live streams on the Lindsay Shiver case. Some of you had asked about that. Would I follow that? Yes, I am going to follow it. I've got 2 partly ready to go. If there's a lot of interest, I may add a third. Lindsay Shiver was arrested in the Bahamas, and she was accused of trying to hire a hitman to kill her husband. He was an ex-football player for Auburn University, and the 2 of them had 3 kids and lived in Thomasville, Georgia. It is a crazy case. One of the great things about that case is no one was actually murdered, although Lindsay Shiver and 2 other people are accused of trying to hire somebody and one of them of being the hitman. They actually didn't succeed in their plan. Robert Shiver is still alive. So I'm going to plan to set those as premieres, which means I hope tomorrow night and Thursday night. So I'll be in the chat with you as it plays, and we can talk back and forth about the case, and I can get your opinions about that. So by all means, subscribe. You do not want to miss out. It's quite the week. And be sure to hit that like button on the way out, and I will see you in the next video.